With that now, ladies and gentlemen, at the very top of this hour, we are tracking this story, very important one that is developing in the Supreme Court of the country. A 7-judge constitution bench of the Supreme Court is pronouncing the verdict as we speak on the issue of minority status of the Aligarh Muslim University. CJI Chandrachud said that the judgment is in 4:3 ratio, with 3 dissenting the minority status of AMU. The CJI has also noted that an educational institution established by any citizen can be regulated under the Article 19, Section 6. The Apex Court has maintained that right under Article 30 is not absolute. Regulation of the minority educational institution is permitted under 19, Section 6, provided it does not infringe the minority character of the very institute. This is the particular case that we are in fact tracking at the very beginning of our bulletin, ladies and gentlemen. The bench in fact was headed by CJI DY Chandrachud, and they're deciding on a reference that arose from 2006 verdict of the Allahabad High Court, which held that the AMU established through an imperial legislation in 1920 was not a minority institution. The reason that was given was the fact that it was established by the British government through the Aligarh Muslim University Act 1920. Now, if we speak of how things have proceeded post that, 1981, the Union government had passed an amendment to the AMU Act in an attempt to restore the minority status to AMU. However, the amendment said that AMU was established by the Muslims of India, and this was in fact struck down by the Allahabad High Court back in 2005. This led to AMU and the Union government appealing the decision in the Supreme Court. 2014, the NDA government led by the BJP withdrew their appeal against this decision. AMU and other associations affiliated with the university proceeded with the challenge. Now, the petitioners have argued that Sir Syed Ahmed Khan had founded the Mohammedan Anglo-Oriental College, the MAO, with an intention to uplift the Muslim community. This was transformed to Aligarh Muslim University after the passing of the Aligarh Muslim Act in 1920. Now, according to the Union government, AMU surrendered its minority status after that legislation. They in fact argued that the Muslim community ceded control of the university to the British government, and further they stated that the promoters of the AMU were loyal to the British government and hence chose to relinquish their religious status to the British. Now, according to Solicitor General Tushar Mehta, several institutions chose not to cooperate with the British government and, unlike the AMU, have minority status today. The solicitor has given the example of, in fact, in the previous hearings, Jamia Millia Islamia to buttress this point. The union also relied on Azeez Basha, which is held that MAU lost its religious status once it was converted to AMU by the AMU Act itself. Now, for the petitioners, if we look at it, AMU was just an extension of the MAO college that was initially established with no advanced role of the British government. They argued that all assets of the MAO college were used to develop AMU, and this includes the teaching staff, the property, the funds and its administrative staff. Petitioners contended that Azeez Basha was incorrect because it could result in an all-minority institution losing their rights once they come under the ambit of the parliamentary statute. Upholding it would impact all minority institutions that in fact operated under the statute, and they pointed out that the court should consider preceding facts like incorporation of the MAO college, its intent and the role of its founders to determine the status of this very university. Now, if we come to the present day, what exactly has been ongoing with regards to this very matter? Without this minority status, AMU will have to begin implementing reservation policies for both their teachers and their students in a similar manner as other public universities. If this status is granted, the university can provide up to 50% reservation for Muslim students. Currently, the AMU does not follow any reservation policies of the state. However, it does have an internal reservation policy where 50% of their seats are reserved for students who have studied in its affiliated schools or colleges. Now, the bench included Justices Sanjeev Khanna, Surya Kant, J.B. Pardiwala, Dipankar Datta, Manoj Misra, S.C. Sharma, They have heard the arguments over the course of 8 days between January 10 and February 1st this year. This was the first set of hearing that had taken place. This issue was decided once before the Supreme Court, as we were just mentioning about the Azeez Basha and versus the Union of India case, which was again heard in front of a 5-judge constitutional bench. Now, the CJI today has said that rights under this particular educational institution can be regulated by the Article 19, Section 6. With that, in fact, to simplify the matters and to explain this in better depth, we have with us Varghese Abraham joining us from the newsroom to bring us more details as to what has been said by the Supreme Court, as the verdict has already come out. They've already started pronouncing the verdict. Varghese, a very good morning to you. Very firstly, help us understand what exactly has been said by the CJI so far with regards to this very case.
What we understand is it is, as of now, early readings of that verdict that is coming in. The CJI has made it clear that there are 4 opinions on it. There is one majority opinion, and there are 3 judges who are dissenting on 3 different aspects. So that is why you have. That's why he said that there's a majority opinion, and there are 3 minority opinions on this particular aspect of whether minority status can be given to the Aligarh Muslim University. Now, Chandrachud has said that on the very first basis that most of them do in fact claim that an institution can be considered minority under Article 30. He said that though Article 30 allows a citizen who could in fact go ahead and given the guarantees whether he can establish a minority institution or not based on linguistic and religious affiliations, well, it is not absolute. He says that the rights under that is not absolute. Meanwhile, he also went on to say that an education institution established by any citizen can be regulated under Article 19(6), which it is maintained that under Article 30 is not absolute, the rights are not absolute, and regulation of the minority education institution is permitted under Article 19(6), provided that it does not infringe on the minority character of that institution. So it says that, on one side it says that the Article 30 that gives the right to establish an administrative institution need not be absolute, and under 19(6), administration can be carried out of that institution as long as the minority character of that institution is not taken into consideration. Meanwhile, he also says that Article 31 cannot be extended to a situation where a minority community which establishes an institute but has no intention to administer it. So there is restrictions that are there when it comes to the interpretation of Article 31, as we see how the CJI is in fact putting it across. The ones which wants greater state control, as we understand, because AMU comes under the central government funding as well, they cannot have a minority tag merely because the establishment of its establishment, and this can be done by way of waiver, is what the CJI has said. Meanwhile, the CJI has also said that Article 30 shall stand diluted if it applies to not only institutes, those which have been established after the Constitution came into force. Thus, education institution established by minority, which was established before the Constitution came into force, will also be governed by Article 30. So he says that, therefore, there are institutions that can come under the ambit of 30, though it is established much ahead of India's independence and before the Constitution was adopted. So those aspects have also been, in fact, cleared out. Meanwhile, as of now, as he's reading it, there are universities which are teaching colleges. This is what he said in this thing, where he says that there were universities which were teaching colleges, and process of converting teaching colleges to teaching universities is a process of forming an education institution. Thus, it cannot be seen this narrowly. It cannot be stated that institute is formed by law just because the preamble of the Act says so. The fundamental rights will be made subservient to statutory language, and formalism must give way to actuality. The court has to consider the genesis of the institute, and court must see how who was the brain behind the establishment of the institution. It has to be seen who got funds for the land and if minority community helped in it. So the court was in fact looking into the aspect of the origins of the university as well when it came to this particular aspect. Meanwhile, the court also has said that we have held that to be a minority institution, it only had to be established by minority and not necessarily be administered by the minority members. That's a very big observation that we are looking at, because the character of administration also is one of the aspects of debate when it came to this particular university. So we have the judge, in fact, the CJI, in fact, saying that we have held.
Varghese, I'm sorry, I'll have to interrupt you there. Thank you for bringing us the in-depth verdict that's in fact being pronounced by the CJI in the Supreme Court right now. In fact, to bring in his insights on the very verdict that is being pronounced, I have with me Senior Advocate Rajiv Nanda with us on the broadcast. Advocate Nanda, very good morning to you. Very firstly, it's a 4:3 decision that we see coming in from the seven-judged bench in the Supreme Court. Some very crucial points given in with mentions of Article 30 having been made, saying that it will stand diluted if the AMU in fact goes on to be given complete minority status at this very point. And also a very important point that's been made is it is not necessarily required to be administered by minority members, more so leaning towards, which implies that more so leaning towards who has established the very university. What are your thoughts on what has been said by the Supreme Court so far?
See, one thing very special is there that this is a 4/3 decision, though this will be called and cited as a 7-judge decision, but practically this is a 4-judge decision, which is overruling the earlier 5-judge decision. Now, at a given point of time in a later stage, I have feeling that this will be again reviewed by yet another larger bench, because this doesn't take us to the majority view of the 7-judge bench. This is, though majority technically 4 judges, but this is not overruling the 5-judge bench, which was by consent of all 5 judges. Now coming to the minority status. See, this by Sir Syed, this was established in 1850, and then later on amendments came in and all that. Now the question was whether this is a minority institution as of now, whether this is, so court has held, yes, it is a minority institution, but a very important point which has been held today is, and which may go against this AMU today, that it is not necessary that the minority people, the so-called establishers or the people from that minority community who had established this, will continue to administer it also. No, administration can be by others also. So this is a very important decision today, like minority status, but can be administered by others.
Absolutely. In fact, Advocate Nanda, please stay with us right now just to bring to the notice of our viewers. Right now, what we are learning is that Supreme Court 7-judge bench, by a majority of 4:3, rules that Aligarh Muslim University is entitled to minority status under the Article 30 of the Constitution of India. Another very crucial point, Advocate Nanda, is the fact that the CJI today has said that this particular judgment will be considered as to whether AMU is a minority institute or not, which clearly mentions that the Azeez Basha case that we keep referring back to whenever the minority status of AMU is considered, is no longer, does not stay pertinent to this case anymore, does not stay pertinent to this ruling anymore. That is, I think, a very historic verdict that's come out from the Supreme Court today, because I think that is the part which caters to this very factor of minorities who've established it do not necessarily need to be administering this very university.
Yes. See, I tell you, the earlier Basha judgment, of course, was by a smaller bench than the 7 judges.
It was a 5-judge bench, yes.
It's a smaller bench. Now, today, it's not that they have overruled 5 judges. Technically, yes, it's a 7-judge bench, but it is by 4/3. So, in my view, this will have to be necessarily considered by a still larger bench of 9 judges. I think not today. Today, this law, which is a majority judgment, is the law of the land. This judgment is the law of the land. This will have to be followed. This, for all purposes, overrules Pasha. Yes, it overrules. But I am giving a practical view that this will have to be reconsidered by a still larger bench of 9 judges. Like earlier, there is a precedent, like Minerva Mills and Keshavanand Bharati. It started with Maneka Gandhi. All those cases, they started with 5 judges, then 7 judges, and 9 judges, and 11 judges. So the view keeps on changing. Here, this is only a view of 4 judges. So this will have to be considered by a still larger bench.
Right, right, Advocate Nanda. Also, do throw some light upon what the CJI has to say with regards to Article 19, Section 6 in today's verdict. Just if you could just break that down, because they've said educational institution can be regulated by Article 19, Section 6. Just help us understand the context of it in today's judgment that's come out.
See, I am yet to see that part of it, what CJI has said. But certainly, you see, he has authored the judgment, giving that if we take away the right of minorities to run or to establish the institution, that will dilute Article 30. So it will have to be read in context with Article 30 only. Any reading given to Article 19 has to be read in conjunction with interpretation given to Article 30.
So, Advocate Nanda, do you think that at this point, in the coming future for that matter, we are to see a 9-judge bench taking up this case yet again, given that you just mentioned today's was a 4:3 ruling that's come out?
I am 100% sure that a 9-judge bench will be constituted. It is only a matter of time. As of now, being advocate of the Supreme Court and citizen of this country, I can share with you that this is the law of land as of now today. But since it is a 4/3 decision, this will have to be reconsidered by a still larger bench. It cannot be reconsidered by a 7-judge. It cannot be. And there cannot be a review now because the CJI is demitting office today. So there is no question of a review of this judgment by the same bench because the bench will not be available. So it will have to go necessarily, a new bench will have to be constituted. It's only a matter of time, whether it is today or tomorrow or maybe a year later or down the lane, whatever time.
Dipping into a little less of a legal question to you, Advocate Nanda, let's also talk about, now that according to this ruling, we see that Aligarh Muslim University has in fact been given the minority status. What would it actually translate to in terms of administration in the university and reservations for this very university? If you could just throw some light on that.
See, the moment you are conferred the status of a minority institution, all those rights which are available for the minority institutions, they start following. They start falling for you. Now, all those rights, when I say, I mean not totally agreeing with the UGC or not totally agreeing with the other institutions established by the government. They can have their own say in matter of admission, in running the things the way they want to, because they are a minority institution, and minority institution necessarily means that they are there to promote their own interests also. They are permitted to do that. So the moment any institution acquires a minority status or it is restored, so all those rights will start falling back again. Like what is happening in Delhi in St. Stephen's College, Delhi University. It will be the same kind of thing. Though St. Stephen's College is a minority college, but under the Delhi University. Here the difference is Aligarh Muslim University is a university in itself. Though established under a central act. But the rights are the same. Again, all those rights which are coming to the minority, they will be available now. But here is a catch. The catch is the moment if other people, then the minority, they start coming on the board, then the decision-making power gets diluted within the board.
Right.
To get something passed in the board of the university, you need to have majority anywhere, and like in any other democratic system. So if gradually, let us say, I mean, I will not mince my words, if the saffron government wants to bring in more people which are not from the minority, so they will eventually have their say, not though having technically the status of minority, they will not be in a position down the lane to pass anything which should be done as a minority, or which they have as a right, not should be, which as a right they could have done.